Respected ma'am and dear participants, a very good evening to all of you. I, Savraj, member of Legal Vidya, welcome you all to the 3-day workshop on Rera. So, without any further ado, let's begin the session. Over to you, ma'am.
A very good evening, everyone. Today is our second day for the Rera session. So let's embark upon this second day session. Give me a moment and I must share the presentation. I would like to apologize in advance. I'm not doing very well. So apologies for the interruptions caused due to it. Today we will be covering few very important Rera concepts. So let's start with the basic definitions that help us understand the sections and the act in general. So, first, we must start with why this RERA Act was created in the first place. It was to protect the interest of home buyers, mainly to protect the interest of home buyers, because the issue that we were facing before RERA was introduced was that builders had an upper hand. They used to so basically allottees are consumers. They used to prove that the allottees are not consumers, and proper remedies were not available to home buyers, as in if project A, B, or C, they were working together at three different projects in three different townships. What used to happen was the influx of funds from the three projects. They used to misappropriately use those funds for either by money laundering or say using another project's fund in another project. Such issues we were facing before RERA was introduced. The main reason RERA was introduced was so that home buyers don't end up losing their hard earned money. They don't lose out on the investment opportunities and the costs and the investments that they have put into the project. They are saved from such fraudulent developers. That was the primary motive for introducing RERA. The act was enacted with those intentions. Let's go ahead and understand what the term allottee means. In section 2 of RERA, section 2D, an allottee is defined as in relation to a real estate project means the person to whom a plot, an apartment, or building, as the case may be, has been allotted, sold, whether as freehold or leasehold or otherwise transferred by the promoter, and includes the person who subsequently acquires the said allotment through sale, transfer, or otherwise, but does not include a person to whom such plot, apartment, or building, as the case may be, is given on rent. To put this simply, basically, an allottee is someone who gets a plot, may it be an apartment or a building in a real estate project, from the developer. The developer will give you an apartment, which for whatever purpose, if you use it, it will still be given to an allottee. This happens through an allotment or via a sale or transfer, whether freehold, as we had understood, freehold means full ownership, or whether it's on a leasehold, basically limited time ownership, land. Even if the original buyer sells or transfers the property to someone else, the new owner is also considered an allottee. I hope this is understood to everyone. Why is this not moving? Mm, mm, it's not moving.
Ma'am, you can turn off your presentation, then again present that. I think there are some technical glitch.
Okay, okay. I'll do that.
Yes, ma'am.
Mm, I'm yet not able to scroll through this. Is it good now?
Yes, ma'am. Now it is showing the section 2K defines carpet area.
Okay, all right. Let's start with section 2E, which is the definition of an apartment. Now that we understood what an LOT is, let's understand apartment in the general sense of it. Apartment, whether called a block, chamber, dwelling unit, flat, office, showroom, uh, please mute yourself. Dwelling unit, flat, office, showroom, shop, go down premises, suite, tenement, unit, or by any other name means a separate and self contained part of any immovable property, including one or more
Yeah.
rooms or enclosed spaces located on one or more floors of any part thereof in a building or on a plot of land used or intended to be used for any residential or commercial use. It could be for residential use or it could also be for commercial use, office shops, showrooms, godowns, or for carrying out any business, occupation, profession, or trade, or for any other type of use ancillary to the purpose specified. They have tried to capture the all the kinds of ways in which a immovable unit such an apartment can be used. An apartment is any separate or self-contained space within a building, or it's on a plot of land. It can have many rooms or it could just be one room, and it could be located on any floor. It doesn't matter what it's called, whether it's called an office or a flat, shop, showroom, etc. As long as it's a distinct unit, it can be used for residential or commercial purposes. It just comes under the definition of an apartment. Let's understand the section 2K, which is the definition of carpet area under the Act. Carpet area means the net usable floor area of an apartment, excluding the area covered by the external walls, areas under services shafts, exclusive balcony or veranda, area and exclusive open terrace area, but includes the area covered by the internal partition walls of the apartment. For the explanation of this, for the purpose of this clause, the expression exclusive balcony or veranda area means the area of the balcony or veranda, as the case may be, which is appurtenant to the net usable floor area of an apartment, meant for the exclusive views of the allotee, and exclusive open terrace area means the area of open terrace which is again appurtenant to the net usable floor area of an apartment, meant for the exclusive use of the allotee. Basically, before Rera introduced the carpet area guidelines, what builders or even the reselling parties used to do is, this is my flat, even if it won't be a terrace area only for their exclusive views, they would show it as a part of the flat, and that exceeding area which would be a common terrace or which won't be a part of the sanctioned layout, because when they are making FSI, they're figuring out the FSI that the building will get, that terrace area is not included in that particular flats layout. So it's not legal to sell that as a part of that flat. It needs to not be covered in that flat area. Only the area which will be used exclusively by an apartment holder would be considered an carpet area. And what carpet area exactly is? Basically area that refers to actual usable space inside an apartment where a person can place furniture or walk around and live. If this area where a carpet area can be laid, hence basically what do? We lay a carpet in a living space, right? Hence this name carpet area comes from. And what is included in carpet area is also the internal walls. So if we live in a flat, right, there are internal walls that separate a living room, a washroom, even that forms the part of the carpet area. So those walls would be included in the carpet area, but the wall outside our home, maybe near the staircase, that won't be counted in carpet area, but that would rather be a super built up area. And earlier what builders used to do is, they used to say 800 square feet super built up area. People would think like, okay, this is a huge apartment, there will be ample of space. And once they get handed over with the possession of that apartment, only to realize that sorry, that this apartment was actually much smaller than what builder promised you, because he tried to also include the area that is around your apartment. So hence Rera came up with a proper definition as to what builder has to specify. They have to only specify the carpet area. If they are specifying any other area, they have to mention it. Okay, so the transparency needs to be there. What doesn't form a part of a carpet area is, the service shafts or exclusive balcony or veranda, which is not on a private space but rather between multiple people. That won't be counted as the carpet area. I hope this is clear to everyone.
Yeah.
Hmm. Now let's understand section 2 subsection M, which defines commencement certificate. A lot of time when we go to buy a flat, we say that OC leke aao, CC leke aao. CC is what? It's not the commencement certificate, but it's completion certificate. Okay, so do not confuse these two terms. We will understand what these two terms mean, so there is no area of confusion available. Let's understand commencement certificate. It means the commencement certificate or the building permit or the construction permit, by whatever name called, issued by the competent authority. Here competent authority would mean the local bodies, BMC or municipal corporation. They issue it. And they issue it to allow or permit the promoter to begin development works. Development works means what? The real estate project that has been sanctioned is called development works on an immovable property as per the sanctioned plan. So basically, commencement certificate is the first addition that you will that a builder has to obtain. And that commencement certificate he will only obtain if he's obtained all the other local body certificates like fire certificate, or whether the water sewage is possible in that area, how is the road connected. So after all of this, only then the municipal corporation will issue a commencement certificate to the builder. It is an approval given by the local authority which allows the builder to start construction. Basically, it's ribbon cutting of a new project, you can say. Without this certificate, a builder cannot legally begin work. And why is this so important? Because it ensures that the project has followed all the legal guidelines and all the zoning laws necessary. And it also prevents unauthorized constructions, and buyers especially should always check if the project has obtained a valid completion certificate before investing in such a project, because a lot of times builders don't obtain completion certificate because they must have missed out on two or three mandatory guidelines or zoning laws, and they still continue building that development work, a project, and then eventually we see a lot of times that BMC will come to that area where the project is taken place and destruct or demolish the entire project. A lot of times this happens. We've seen it in news as well, right? So now let's understand what is a completion certificate here. Section 2, subsection Q defines completion certificate, which means a completion certificate or such other certificate by whatever name called, issued by the competent authority, certifying that the real estate project has been developed according to the sanctioned plan, layout plan, and specifications as approved by the competent authority under the local laws. Here, local laws is very important because local laws geographically change. All the states have different zoning laws, different land laws. So, a builder has to see all of those different parts of laws, and he has to see whether these permissions are fulfilled or not, time to time, and get all of those permissions before he starts a project or even before he goes to Rera for a registration of such a project. As we understood a commencement certificate, we need to understand what exactly completion certificate would entail. A completion certificate is issued again by a BMC authority when a real estate project is fully constructed as per an approval plan and meets all the legal requirements. Whatever steps which are needed to be followed by a promoter, if those steps are followed, only then in its entirety will a completion certificate be issued to a builder. A project, when fully constructed and when all the plans are approved and legal requirements are met, a builder gets a completion certificate. But when the initiation of real estate plan takes place, he will get issued what? Commencement. So please do not get confused between the two. All right, let's go ahead. I hope this was understood to everyone. Now let's understand the rate of interest chargeable from the allottee by the promoter in case of default. Whenever a development agreement is made, there are a lot of clauses stipulating arrears of payment and the penalties on them, and many other facets to as per day how much interest would be applicable to the allottee and also to the promoter. So here we'll understand the interest payable by the allottee to the promoter. In case of default, it should be equal to the rate of interest which the promoter shall be liable to pay the allottee in the case of default. Basically, it shouldn't be unfair, right? The rate of interest, what a promoter has to occur or what a allottee has to occur, it should be fair. If a buyer delays a payment, then they must pay interest to the builder. And if a builder delays giving possession or refund, they must pay the same rate of interest to the buyer. And the interest rate, it must be fair to both the parties. And why is this rule important specifically is because it prevents the builders from charging higher interests on buyers, while they might evade by paying lesser interest on delays on their side. This should not be like this. It should be accountable. They should be accountable, and hence it's important and it's defined here that the interest should be fair to both the parties. So I hope this is clear. I'll just like to give an example on this. If a buyer is supposed to pay an installment of say 5 lakhs on January 1st, but he ends up paying it late in March or maybe subsequently, even later, the builder can charge interest only for the delay. And similarly, if a builder was supposed to hand over the flat in December 2024, okay, but it he ends up delivering his commitments by June 2025, then he must also pay interest to the buyers for those 6 months that he has delayed the handing over of possession to the allottee. Here, we'll understand interest payable by the promoter to the allottee shall be from the date the promoter received the amount or any part thereof till the date the amount or part thereof and interest thereon is refunded, and the interest payable by the allottee to the promoter shall be from the date the allottee defaults in payment to the promoter till the date it is paid. What it means here is, if a buyer gives 10 lakhs to a builder in January and builder is supposed to hand over the flat in January 2024, however, builder fails to deliver the flat on time and refunds the money in June 2024. So basically, now the builder must pay interest for the entire delay period and not just the delay period that has not been incurred. I hope this is clear. I'd like to go ahead. Section 2, subsection ZF defines occupancy certificate. I think we had discussed this particular certificate as to why it is so important, and we must understand it today as well because it's a very important part of our act. It means occupancy certificate or such other certificate by whatever name called issued by the competent authority permitting occupation of any building as provided under local laws, which has provision for civic infrastructure such as water, sanitation, and electricity. Only the approved sanctioned plans get the occupancy certificate. So, say a building is of was sanctioned for the builder or the promoter got a sanction plan that only construct a 20-story building, but if he goes ahead and illegally constructs 3 additional floors in that building, will he also will those 3 stories that he's constructed beyond the 20th floor won't get an OC because they are not legal, it's not transparent. He has constructed with the intention of greed. He did not get the permission of constructing till that level in the first place, may it be because of zonal laws or because in that particular area what is the permission that the local authority has given to other builders as well. So if he ends up illegally constructing the floor, those particular occupants won't get the CC. If they won't get the CC, whatever civic infrastructure here that's mentioned in the definition would entail what? That the water supply, even if you must have seen a lot of flats don't have this OC, but still they get electricity and water supply, but they face so much issue while selling that flat because if BMC gets aware of this illegal construction, anytime they might lose their water and sanitation and electricity supply. So they might lose out on it because that wasn't a sanctioned part of the building. Builders do this without receiving complete OC. They do end up selling those units, which is not right. And it also confirms that building has followed all the basic infrastructure needs, and without an OC, residents may face legal issues also because banks may refuse them home loans for projects without an OC. And what is the difference between CC and OC? One question must have come to your mind because CC completion certificate means what? That everything is done by the builder and now the project is completed. And what is CC? It again means that the project is completed right? Both in a sense look very similar. They seem to be very similar certificate, but here the crucial difference is that in completion certificate, it confirms that the construction is as per the plan given when the building is completed, and it's issued right before OC is issued. And when occupancy certificate confirms that the building is safe for occupancy, and it is given when all the facilities like water, electricity, etc., or fire, NOC, etc., are in place, and it is issued after CC. So remember, first CC is issued and then the OC is issued. Let's move ahead and understand. I have mentioned a lot of times promoter, promoter. What does promoter actually mean? A person who constructs or causes to be constructed an independent building or a building consisting of apartments, or converts an existing building or a part thereof into apartments for the purpose of selling all or some of the apartments to the person and includes his assignees, or a person who develops land into a project, whether or not the person also constructs the structures on any of the plot for the purpose of selling to other persons, or some of the plots in the said project, whether with or without structures thereon, or any development authority or any other public body in respect of allottees of a building or apartment, as the case may be, constructed by such authority or body on lands owned by them or placed at their disposal by the government, or plots owned by such authority or body or placed at their disposal by the government for the purpose of selling all or some of the apartments or plots, or an apex state level cooperative housing finance society. And okay, where was I? An apex state level cooperative housing finance society and a primary cooperative housing society which constructs apartments or buildings for its members or in respect of the allottees of such apartments or buildings, or any other person who acts himself as a builder, colonizer, contractor, developer, estate developer, or by any other name, or claims to be acting as the holder of a power of attorney from the owner of the land on which the building or apartment is constructed or plot is developed for sale, or such person who constructs any building or apartment for sale to the general public. They have covered this in a way that anyone cannot evade from the liability of being a promoter. They have covered each and every facet. Basically, to understand this in simpler way, a promoter can be either a builder or a developer. Okay, someone who constructs a building, may it be residential, commercial, whatever intention that there is. If someone who constructs a building with an intention to sell the apartments to the buyers, basically with an intention to have funds for the works that they've done, even if the same person hires a contractor to build, or they are still considered a promoter. Even a contractor can be considered promoter if he takes the project himself. Could also mean a land developer. What does a land developer mean? Basically, someone who develops land into plots and sells them with or without constructed building. Even then, he will be considered a promoter. For example, say a company that buys an agricultural land and converts it into residential plots thereafter and sells them would be a promoter. He would also come. Look, it's not necessary that it has to be a building only, first floor, second floor, third floor. No, it could also be a land developer. Even he will form a part of promoter and hence also be covered by RERA. It could also be a government authority or any public bodies. So if a government agency like Mahada or Sidco in Maharashtra, similarly DDA in Delhi, and many other state-wise government authorities that develops the land and constructs apartments and sells them, even those authorities are considered promoters under RERA. The housing societies is another aspect of this. There are a lot of societies that you must have heard that they're going to do redevelopment on their own, self redevelopment, right? They might not go to a builder, they have sufficient funds. All the members in the housing societies all together have agreed that we will take up this project on our own, go through the BMC and the municipal authorities and get the certificates. They've decided that they want to develop that particular building. Even they are covered in this definition. Correct. Basically, if a cooperative housing society constructs apartment for his member, it is treated as a promoter. This applies to state level housing finance societies, and it also applies to primary housing societies. A person who acts as a landowner is also covered under this aspect of promoter. A person who acts as a landowner means what? If someone holds a power of attorney from a landowner and sells the apartments or plot, they will be treated as a promoter. ऐसा नहीं है कि landowner will be like, you keep the power, you sell it, I would still be. No, they both will be liable. They both would be promoters. And it also means that any other person who constructs and sells the building, remember this, construction is happening, building, plot, if even if it is sanctioned, if it is getting sold, it will form a part of promoter under RERA. I hope this was understood. This was quite a lengthy section and also very important one. Here, let's go through this explanation also. We've read the section. For the purpose of this clause, where the person who constructs or converts a building into apartments or develops a plot for sale and person who sells apartment or plots are different person, then in such a case, like I told you, power of attorney a landowner gives to the holder, both of them together shall be deemed to be the promoters. I think we've covered this. Let's go ahead. This is the most important section here, a very lengthy one again. And I hope I'm not going too fast or slow. Are you all understanding? Please write it in the chat box. Is it going in the good speed? Okay, great. Thank you. Just give me a minute. I'm so sorry for this. Now let's understand this section. Prior registration of real estate project with real estate regulatory authority. Basically, what are the priorities that a builder has to keep it in mind before he sends a particular real estate project to RERA for getting it registered? This is basically a checklist and a to-do list that a builder needs to keep in mind. Let's go ahead and understand it. No promoter shall advertise, market, book, sell, or offer for sale, or invite persons to purchase in any manner any plot, apartment, or building as the case may be in any real estate project or part of it in any planning area without registering the real estate project with the real estate regulatory authority established under this act. What it means that if you have to go ahead and develop a project it can only happen if you have registered the real estate project with the RERA authorities. Provided that the project that are ongoing on the date of commencement of this act, or for which the completion certificate has not been issued, the promoter shall make an application to the authority for registering the said project within a period of 3 months. I'm sure this has passed. Basically, even if before RERA had come, if you were still building a particular project, all those projects also form a part of RERA registration. Provided further, if the authority thinks necessary in the interest of allottees for projects which are developed beyond the planning area, but with the requisite permission of the local authority, it may, by order, direct the promoter of such project to register with the authority, and the provisions of this act or the rules and regulations made thereunder shall apply to such projects from that stage of registration. Notwithstanding anything contained in the subsection above, no registration of real estate project shall be required where, remember this, a RERA registration is not compulsory where the area of land proposed to be developed does not exceed 500 square meters, or the number of apartments proposed to be developed does not exceed 8 inclusive of all phases. Basically, if it's a plot which is smaller than 500 square meters, they need not get themselves registered with RERA. They can start only by taking permissions from local authorities. Basically, the municipal corporation and BMC will still be a part, all the local laws will still be a part of his development plan, but he need not go to RERA. Or even in such a case wherein the apartment does not exceed 8 phases. Basically, 8 units of apartments. Provided that if appropriate government considers it necessary, it may reduce the threshold below 500 square meters or 8 apartments as the case may be, inclusive of all phases for exemption from registering. But if the government considers it necessary, then they might issue a notice to that particular development project and tell them to get themselves registered with RERA. The government, of course, has a say in it. If they feel, then they need to go through RERA registration. B, where the promoter has received completion certificate for a real estate project prior to commencement of this act. So even if he's received a CC prior, then he need not go to the RERA, right? Because he's already received the certificate. He's done it all. It just needs to be sold. And for the purpose of renovation or repair or redevelopment, which does not involve marketing, advertising, selling of any new allotment of any apartment. Basically, our buildings go in redevelopment, right? So they need not go to RERA just for the purpose of renovating. Basically, such renovations won't increase the number of units in a particular building. So there is no selling intention involved. When there's no selling intention involved, it need not go to RERA for registration. Okay. Let's go ahead and understand section 4, which is application for registration of real estate projects. What application is required by the RERA authority? We'll understand here in this section. Every promoter shall make an application to the authority for which the registration of the real estate project in such a form, manner, within such time, accompanied by fee as may be prescribed. Basically, there are prescribed fees which will depend on the type of project, township, or the commercial complex. Based on that, every promoter will have to pay the prescribed fees, which will differ state-wise. The promoter shall enclose the following documents along with the application referred in subsection 1, namely a brief details of his enterprise, including its name, registered address, type of enterprise, proprietorship, societies, partnership, companies, competent authority. Basically, whatever they're part of needs to be disclosed here in the brief detail section. This will ensure what if he, even if he is a part of another company and he's taken another project and he's defaulted, it won't be hidden here because he'll have to put his partnership ID and all the other important details here only. And the particulars of registration and names and photographs are also attached of the promoter. A brief detail of the projects launched by him in the past 5 years, whether already completed or being developed as the case may be, including current status of the said project, any delay in its completion, details of cases pending, details of types of land and payments pending. They also have to disclose all the other projects that they are working on and what all is pending in those projects, and the status of those projects also would be considered. Basically, if that particular promoter has already taken a huge project on which he is lagging behind, he's not defaulting also, but say Rera authority might feel that okay, he's not filed two of these things, he's not completed certain requirements in those projects, then they will put a halt on the new project also which he's trying to create. So hence this is so important, this section, because if a builder is not perfect in an aspect of an old project, he won't be given permission to take up this new project. An authenticated copy of the approvals and commencement certificate from the competent authority obtained, basically all the phases that he's taken. Basically, developers have to make a layout plan in phase. So if they end up taking a huge project, there will be phases of those projects. Say phase 1, they promise that they will start the construction of A, B, and C wing, and then thereafter they might start the phase 2 and phase 3 if it's a huge township. So they have to very clearly state the phases and the timeline and details of each of such phases in the detailed brief layout plan. The sanction plan, layout plan, and specifications of the proposed project or phase thereof, and the whole project sanctioned by the competent authority. The sanction plan and layout plan, along with all the phases, the competent authority needs to approve. Is it even possible if he takes, say, 3 phases? The timeline should add up. So even that would be calculated. The plan of development works to be executed in the proposed project and proposed facilities to be provided thereof, including firefighting facilities, drinking water facilities, emergency evacuation services, and use of renewable energy. Whether there could be a provision to even start, okay, got scrolled. To start a project also they will first assess, is the electricity facility possible? It's not fair if you take up a project in an area wherein the basic habitable needs which require to be fulfilled are not possible. So if any apartment or building which does not have good electricity connections or water facilities available, then they will get rejected there and then, because they will check all the permissions, correct, as we had discussed above. Pro forma of the allotment letter, agreement for sale, and conveyance deed proposed to be signed by the allottees.
Yes.
The conveyance deed of the builder, basically before he starts a project or finalizes on a plot of land, the conveyance deed is nothing but the ownership rights of builder, that this is the project and this is my conveyance deed. Even that will be considered, and the pro forma of it along with the allotment letter would be attached. The agreement for sale that he must have signed will also be attached in this application. The number, type, and the carpet area of apartments for sale in the project, along with the area of the exclusive balcony, exclusive being very important. If the balcony is a part of the apartment, only then the exclusive balcony area or veranda areas and the exclusive open terrace areas are pertinent with the apartment, if any. The number and the area of garage for sale, even the garage, the parking agreement needs to be in place. In the said project, what the builder has promised, basically, this many open parking areas, stilt parking areas, this will be sold along with the particular flat. That will be different, right? Then the allottee will have to pay along with the flat also the money for the parking area. And in case of open parking area, how to go about it, correct? That also needs to be attached in this project detail. The names and addresses of his real estate agents, if any, for the proposed project. Rera certified real estate agents, basically. Uh, any real estate agent who needs to be a part of such a project will have to register himself with Rera first. And then those registered, Rera registered real estate agents, only the builder can hire for his project. He also have to mention the details of all of those real estate agents who are going to be selling the apartments on his behalf. The names and addresses of the contractors, architect, structural engineer, if any, and other persons concerned with the development of the proposed project. Even the PMC, the contractor or structural engineer who go to that particular plot and assess the structure, basically how the road is in front of a building, then that requires structural audit, right? It needs to be at a safe distance from the plot he's developing. It should not go on the BMC area of it. The construction should be limited to the plot for which the builder has received the permission sanctions. So for which structural engineers are important, or any other person concerned with the development of proposed project. A declaration supported by an affidavit which shall be signed by the promoter or any other person authorized by the promoter. Whatever he is declaring, which will eventually be stated, would be as follows: that he has a legal title to the land on which the development is proposed, along with legally valid documents with authentication of such title if such land is owned by another person. That the land is free from all the encumbrances. Basically, even builder will have to check, right? The land he's purchasing for the construction, is it free from the encumbrances, basically obstacles? We had learned in the previous lecture that he will also go through the encumbrance certificate, or the case, or as the case may be, details of the encumbrances on such land. You must have always read a document, development agreement. In the recital parts, it's mentioned how the builder got the ownership, before the builder, who were the owners. Basically, the history is also included. And the builder in the development agreement has to be very transparent as to what all litigation is going on currently on that piece of land. Is it an encroachment which he's looking after and he thinks that no, this he will sort it out? Then he has to mention that also. If he thinks that there's a lot of time there's a common compound between two buildings on which there is litigation going on, he has to mention that in his development agreement, so that the allottees are well aware of their investment risks, and also he has completed his part of being transparent. So he has to put that in development agreement, as the case may be, correct? So legal title part is clear here, that the land is free from all the encumbrances should be included. the time period within which he undertakes to complete the project or phase thereof, as the case may be. Also, in the development agreement, he has to mention that the phase A and the details of phase A, the phase B and the details thereof, and how he plans on taking the commencement of each of such phases. That the 70% of the amounts realized for the real estate project from the allottees from time to time shall be deposited in a separate account to be maintained in a scheduled bank to cover the costs of construction and the land cost, and shall be used only for that purpose. This is the best provision under the acts which indemnifies the home buyers. The 70% of the funds that they will receive from all the allottees would be kept in a separate account. That separate account is called as an escrow account. It is a third party account in which they will put 70% of the funds of those home investors, and the only 30% part of the fund will be open for the construction costs or the permissions or the fines, delay, whatever he needs to do, he has to manage it in that 30%. Once that is utilized, only then he can reach out for the 70% part of the fund. Provided that the promoter, here it's mentioned, provided that the promoter shall withdraw the amounts from separate account to cover the cost of the project. He also has to furnish the proof that whatever 30% fund that was open to be used, how did he use it, and as to why he needs to approach for further funds in proportion to the percentage of completion of the project. Provided further that the amounts from the separate account shall be withdrawn by the promoter after it is certified by an engineer, an architect, and a chartered accountant in practice that the withdrawal is in proportion to the percentage of completion of the project. Right? These three parties, a chartered accountant, an architect, and an engineer, will be evaluating how the funds need to be used further. They will make a report basically. Provided that the promoter shall get his accounts audited within 6 months after the end of every financial year by a chartered accountant in practice, and shall produce a statement of accounts duly certified and signed by such chartered accountant, and it shall be verified during the audit that the amounts collected for that particular project have been utilized for that project, and the withdrawal has been in compliance with the proportion to the percentage of completion of the project. So as we discussed above, that these three will make a report, and then that needs to be submitted, and it needs to be in proportion. Correct? I think we should stop here and we can continue. This is another very important and big section. We can continue it today. I shall take doubts of the students. If any, please, I encourage you all to ask me questions. Let me know what are your doubts. You all can unmute yourself.
Hello, ma'am.
Yes.
I have one doubt. Like
Yes.
you were talking about the carpet area, so I would like to know what all, like the dry balcony, will it be included in that carpet area?
Yes, dry balcony forms to be a part inside the home, right? Dry balcony is attached to a washroom, correct? So a
Yes.
dry balcony is for exclusive use. No one else can come in and use your dry balcony, right? So it will still form a part of carpet area.
And what all things cannot be included in the carpet area?
So basically, any area which won't be exclusively used, okay? So you enter flat from the entrance, correct?
Yes.
From there, the living space and the particular veranda, if it's a different kind of township, okay, then even the veranda which is exclusive to you will be counted in carpet area. From there to, say if there's a terrace, then that terrace is separated. Okay, it's a part of that home, even that will be considered. Your washroom area, of course, dry balcony, bedroom, kitchen, all of that will form a part of carpet area. What won't make a part of carpet area would be gaming or theater, right? Because it will be commonly used by all the residents in that particular building, correct? So
Okay.
hence
Uh-huh.
that won't be a carpet area. But earlier they used to sell it. No, they have wronged a lot of allottees in the past.
And the parking area, which is if we are purchasing the parking area,
Hmm.
so will that also be counted?
Yes, we mentioned in the agreement if that parking area is exclusive. Okay. If it's an open parking area, say in a building there are 50 residents. Okay. And exclusive parking areas only constructed for 25 flat holders.
Mhm.
Then we pay stamp duty even on those exclusive parking area, right?
Yes, yes.
Whenever we go, we buy an apartment, we do pay stamp duty. But the open parking area, no, which won't be exclusively allotted to the flat owners, those open parking areas won't be counted. We write in
Okay.
agreement carpet area along with this the parking space, the garage or whatever.
Mhm. And one more thing, like you were talking about the uh, areas or the homes or the units which will not be coming under RERA, like they
Yes.
need not be. So you talked about 8 individual units. I
Hmm.
mean, if a building is having 8 apartments, so that won't be considered in RERA.
So there are two facets to this. A, it should also be within 500 square meters, correct?
Yes,
First
yes.
you'll see कि is it within 500 square meters, then there's no question, right? But if those 8 apartments are so huge that they cross the 500 square meters, like say Ambani's home, right? It
Mm-hmm.
might be maybe in those 500 square meter or certain area. But if it is, just a second, huh? Yeah, so if within 500 meters they are creating more than 8 units, okay, first this is clear कि चलो 500 square feet के अंदर है. But on that, if he's creating 8 units, 12 units, 15 units, then they'll have to register because वो 8 तो exceed कर रहा है. But दोनों चीज हो रही है ना, if it's within 500 square meters and it's also within 8 apartment units, then he need not, because it's a very small space.
Okay. Thank
Okay,
you. Thank you so much. Yes, thank you.
welcome. Anyone else?
Are you able to hear my voice?
Yes, sure.
No. The thing is, in the Rera Act, I am an Hare Krishna advocate from
Right,
Madras. In
right.
the Rera Act, the director, how many times can be extended for the project?
Extension is max up to 1 year, sir. And for that also he has to mention what are the reasons for which we already know there's a force majeure
No,
clause, right?
actually, the first time the project was being extended till 2023. Thereafter, 2024 December. Thereafter,
Hmm.
the one of the director has been extended until the December 2025. Is it right on the part of the director of RERA?
Only if he's made a very strong argument to the RERA authorities. Say if there's a huge delay in BMC authorities part or something, only then that extension is right. Otherwise, no.
But
Because
that one
in the
year,
act,
one
no,
minute,
particularly
one.
specifies that at the max you'll get for 1 year. But when COVID was going on, many builders were able to claim beyond 1 year period as well, right? Because it was not
Definitely,
in their hand. So in such
definitely.
case, it's forming a reasonable timeline. But if it is not reasonable, then it's not correct.
No, reasonable. But the force that one year extension is applicable only for the force majeure or for all. even if it
Post
is not a
force
force.
majeure. No, no.
Force,
Force majeure is not included. The
force
six
measure is
months.
not included, but the director can extend
Yes.
only one extension, isn't it?
Yes. One
Yes, okay.
maximum year, and for which he will have to. There will be a
So
hearing on.
there, interest of allot is to be obtained.
No, if he's getting an permission, then in that case, interest
No,
allottees
any
won't get.
extension of the project, any extension of the project, two-third
But it
majority
is
of the
Rera
allottees are
approved,
to be
right?
there. Allottees are to be there.
The
But he has
allottees.
been obtained a permission only 113 out of 2,300, isn't it?
Hmm. Hmm.
2,300 allottees are there, but he is obtained. He's been obtained 113 members and extended the project. It is quite against the interest of allottees or not?
Yes, it is. It is. And in that
Yes.
case, they can definitely approach Rera also, and they
I
will.
approached that. I approached that
They
the
have.
extension is very quite wrong. And also two
Yes.
escrow accounts are been maintaining. That is also have been challenged. But the registry attached to the Tamil Nadu Rera
Right.
is been put into the maintainability.
Hmm.
Then chairperson headed by another member has been, why you are coming here? You go to the appellate authority. Can I go to bypass that original authority to appellate authority? Can
First,
he
the
say?
Rera authority will need to hear your case.
He
Only
says
then
no.
you have to.
He says you go to appellate authority. I said that appellate authority I cannot bypass the original authority. Original authority is having every right to decide the issue because I have been
Right, yes,
extensively
yes.
argued.
Only if you are not pleased, then you go to the appellate authority.
No,
Correct?
yeah,
Mhm.
I've been challenged, but orders have been reserved. That is only thank you for your valuable answer.
Okay. Thank you so much, sir.
Thank you.
Anyone else in the lecture? Please feel free to bring up your questions. I think Rishabh ji. Yes,
Excuse me.
yes.
You told that it should be like for not registering with RERA, the unit should be within 500 square feet meter, and there should be only 8 units.
No,
But
not.
what about
Hmm.
and what but what about if the building is constructed on a land which is having more outer space?
Outer space, as in what? BMC
Like,
space?
yeah, the open space.
Open space, builder has to buy that open space, right? Only then he will be entitled to that open space.
Yes, yes.
So
But
if
he is
it's not his,
constructing.
then so in conveyance deed, the area is very specifically mentioned, right? What is his area? So then
Right.
that will come into the picture. If there is another compound or say even a huge 3 acre land available next to the building, but it's not his in the first place, it might be owned by someone else altogether. So then he need not go to RERA, right? Because it's
No, no.
not his entitlement.
Yeah, yeah. If he has purchased a huge land, but if he has used only a part of it for constructing the building,
Hmm.
so
Then if he's doing phase wise, okay, then
Mhm.
he need to approach because there will be second phase also, right?
Yes,
And we
yes.
did, yes, but like we studied in the act that if it is phase wise, then all the phases he'll first have to sanction the layout. If the layout, if he's not planning to construct right now, okay, he has a huge uh, plot, okay, then he will, there'll be CTS number, right, the city survey numbers of those particular plots. He has to select what would be his layout. If within that layout he's only constructing several units and it's within that 500 square meter, then he need not approach RERA because he's not going to use other, right, it's not been
Yes.
sanctioned only.
Mhm.
But if he goes ahead in future, okay, and decides to construct, and if then that construction, if it is falling above 500 square meters, then he will have to approach RERA because it is forming a part of higher space index.
Okay, and then this unit will also be registered under RERA.
No, that unit would be treated differently because when a builder has already committed, Okay, and he sold those flats, okay, and someone else buys that land from him, then what? Because the ownership will change, no? He's done his work. He sold those apartments, then there another conveyance deed can also be taken place. That if it is not phase wise, it's a different project, then it won't form a part.
Okay, okay. Thank you. Thank you, sir.
Welcome.
Disha ma'am,
Yes.
yeah. When a customer or allotee buys a flat from
Hmm.
a builder, okay, and
Hmm.
if uh, the buyer
Hmm.
doesn't make the payment as per the schedule, whatever the payment schedule, okay,
Hmm.
or if he's not adhering to any policy, or if he's not, uh, I mean, which is not as per the what was the
Agreement.
contract made, okay, so the buyer will have to pay the penalty
Hmm.
from his or her account, right? His or
Hmm.
her own money, okay.
Yes.
Now when the opposite, when the builder or promoter violates
Hmm.
any
Hmm.
conditions, okay, then the builder will pay, right?
Yes. Correct.
Huh. So the money which he has collected from all the buyers, okay,
Hmm.
which he would have, okay, from
Hmm.
that he would pay the penalty, or he would pay from his personal account.
Yeah, he won't use another buyer's funds to pay the penalty. That would be his personal account.
Uh,
Because he escrow account में जाता है इसलिए पैसा, right?
but
So
escrow account
already,
is
so
70%. You said that is
this is fixed. Okay, in the initial time, 70% is fixed. 30% is there for which he has to generate receipts.
haha,
Receipts, I mean. Okay, he'll have to furnish no proofs how he has spent the 30%. He's
I
answerable.
know, I know,
Then
right?
if he has to pay penalty, it won't be on home buyer's money, because that 30% is any which ways going to be spent in other things, and the 70% he can't touch, which is already in an escrow account. So the penalty that he'll have to pay would be from his company's account.
I know, but all the 70 and 30% is from the buyer's money only. No, it is not. I mean, none of this
But
money is his
if
personal
he
money,
will
right?
be a promoter, right? He will be
Uh-huh.
having his own funds, right? He can't use
Uh-huh.
70%.
Okay.
His company will also, he'll have to put attachments, right? When he's making an application.
Uh-huh.
Yeah, so he won't, the other home buyers won't suffer his neglect and default.
Right, right. Okay. Thanks.
Welcome. It was an interesting question.
Hmm.
Just a second. Anyone else?
Anyone have any queries? Kindly unmute yourself and ask. Otherwise, we can end this session.
No, how many escrow accounts to be maintained one builder?
It is phase wise. So
Phase
one
wise.
is yes.
Yeah, but builder has given one escrow account to the allottees to deposit the amount, whereas the bank has given another number, another escrow account number to Rera to deposit. Is it what is that? The buyer having a remedy, or whether he has been connived with the bank?
Under Rera, no, he can only maintain one escrow designated account.
Definitely, but
That's the rule, right?
builder or no,
Single
build,
account per project, and the
correct.
utilization is also specified, right?
Correct. Only one project builder requested to deposit one account. That's called an escrow account.
Right.
1 month later, that the builders are being keep on trying depositing that account which builder has given.
Hmm.
But bank has given to the letter to the Rera.
Hmm.
Another account is an escrow account. What
Hmm.
is the remedy for the buyer?
He will be
Allottees. Allottees.
first of all, each project he is only supposed to give one account, right? Have one
Yeah,
account.
definitely. Definitely.
Yes. So then I'm not understanding what your question is. Bank gives letter
Question
to
is,
Rera as to what?
no, I will tell you again.
Hmm.
The builder requested to all the allottees to deposit the amount. One
In a
account has been
different
given
bank.
in a no, same bank.
Hmm.
Same bank, one account number is given.
Hmm.
Then the buyers are will keep on depositing the amount as per the phase wise.
Hmm.
Sometimes
So
later,
allottees can reach out Rera, no, because it won't be right because he has to only take money in that specific escrow account.
but two escrow accounts are coming or no for one single project.
That is not right, no.
But they are doing now.
A lot of things, no, in
So what is the remedy
practically.
for the allottees?
I think I will just take questions for this because we are about to, we will study this tomorrow
Okay,
because,
ठीक है.
okay.
Okay,
So,
okay, okay, okay.
yes,
Thank you.
I will
Thank you.
definitely get back to you tomorrow on this.
No,
Okay, I
the
will
reason is
also
no.
want
I'm
to
again explaining you. The
research on
reason
this.
is no.
Yes,
I'm
sure.
reasoning is I'm explaining you.
Hmm.
The builder requested all the allottees to deposit the amount in a phased manner. One account number is given, same bank. For
Hmm.
example, X bank. Okay.
Hmm. Hmm.
Sometimes later, the
Hmm.
bank is informing to the Rera,
Hmm.
this account is the escrow account for this project.
Hmm.
Is it connived with the builder is connived with the bank or connived with the director? If so,
Hmm.
what is the remedy for the allottees?
I would definitely get back to you on
Okay,
this tomorrow.
okay,
I'll
okay.
have to read some more on this, but I will get back
Yes,
to you tomorrow.
no problem. Thank you.
Thank
Thank
you.
you. Thanks.
Okay, now we can wind up this session. Thank you so much, ma'am. Thank you so much, participants, for joining. We look forward to you in the third session that is scheduled tomorrow.
Thank you so much, everyone. Thank you to Legal Vidya as well.
Thank
I
you.
will
Good
now
night.
wrap up
Good
the
night,
lecture.
everyone.
Good night. Thank you.